Hello and welcome to the Labor Law Insider Podcast. I'm your host, Attorney Tom Godar, and I work with Husch Blackwell and have been involved in labor law for, more than 4 decades. I'll tell you what, there has been a wild ride over the past 3.5 years of the Biden administration. He fulfilled his promise to be the most union-friendly president ever. And as a result, between General Counsel Abruzzo and the National Labor Relations Board, there's been a sea change in the way that labor law has been interpreted and applied. So we will have guests to discuss what's new, what's challenging, and what might be the ways in which our friends, our clients, and others advising companies might do to accommodate these changes in the labor law world. It's a wild ride, so buckle up and come and join us on the Labor Law Insider Podcast. Hello and welcome once again to the Labor Law Insider. This is Tom Godar, your host, and we are looking at changes that take place in labor and employment laws that we want to bring to your attention, and especially those that affect your current policies, maybe your current practices or agreements. And once again, the NLRB does not disappoint. Today, we're going to talk about the latest iteration of the board saying no to really long-time employment and employer practices. For a while, for a year or more, the National Labor Relations Board has told us that it would not allow employers to have non-compete agreements with those who are otherwise covered under the board's rules, laws, and jurisdiction. The FTC got in on the act too, and we're going to talk about both of those things. But what we're going to focus on today is the new recognition and offering by the National Labor Relations Board and its General Counsel that so-called pay or stay provisions in agreements are also illegal and subject to fairly harsh enforcement remedies if an employer is engaged in that sort of activity. I'm joined today by, one of my favorite guests, Tyler Patko. One of my partners at Husch Blackwell works out of our California locations, but practices all over the place, recognized in all sorts of what I call vanity lists, but they have some value as one of the best lawyers around. I was looking at what I could, Tyler, on the web for more information about you. I was just, what is that called? And you're stalking or something? I want to find out something you hadn't told me. So I looked up Tyler Patko and 5 or 10 of the list down after I got through Husch Blackwell and best lawyers and all those things. It said that you had a life that I didn't even understand you had. You had written a paper this year on inductive risk and epistemically detrimental dissent in policy-relevant discussions. It was written in the European Journal of Philosophy of Science. I didn't know that part about your life. Tell me more about it, man.
So I'm not familiar with that publication, Tom. I'm trying to think back. I did write a history thesis on University of Michigan campus administration interaction during the 1960s. So that might have been picked up in that European journal. But since then, it's been all law for me.
You must have an unknown but somewhat famous relative who's a philosopher. And I know that you wax philosophical about Michigan football, Tyler, but
that sounds more interesting, the philosophy career, but I'm not there yet.
All right. Well, you'll have to look up the European Journal of Philosophy of Science.
I will.
My undergraduate was really spent in the philosophy of education. Why I became a lawyer is a whole different story. So I really kind of dig that, but I'm not sure if I even understood the title. But mostly it says that dissent, as I started reading the cover, that dissent in science isn't always an excellent idea, even though that's how science advances. Kind of a compelling narrative. But let's not hasten ourselves into the irrelevant any further. Let's talk a little bit about what's happening in the labor law world. First, tell us a little bit of background, Tyler, on what's going on with the National Labor Relations Board and non-compete agreements, stuff that our clients have used or not used for many, many years. How is that changing, first over the last couple of years, before we get to the pay or stay questions that have arisen since October 7th?
Yeah, thank you, Tom. And it's great to be on the Labor Law Insider again. It seems like the NLRB just keeps giving us more gifts, and this is another one. This area has already been the subject of a lot of debate. I know that under the Obama administration, there was a committee formed to study no poaching agreements, restrictions on employee mobility. Nothing ever came of that. There was a bill in Congress to ban poaching, no poaching agreements, or to prohibit employers from restricting employee mobility, but it never got through the Senate and the House, was never presented to the president. But it's been a rumbling, here now for about a decade. We did have the FTC. Well, let me just go in order. In May of 2023, so over a year ago, the NLRB General Counsel, Jennifer Abruzzo, the gift that keeps on giving, issued an advice memorandum that surprisingly, we think about the NLRB, we think about union activity, election activity, organizing activity, unfair labor practice charges, and they're kind of veering into areas that traditionally they have not spent a lot of time. So May of 2023, there was a memo authored opining that the proffer, maintenance, or enforcement of non-compete provisions, post-employment non-competes, violates the National Labor Relations Act. The theory of this May 2023 memo was it violates Section 7, and the General Counsel, Ms. Abruzzo, emphasized how these provisions, including non-competes and now stay or pay provisions, interfere or infringe on employees' Section 7 rights to find a better job, to complain about the workplace. And at least the NLRB has opined that these provisions are not only unlawful, but she wants to find a real remedy for them and not just talk about it. So May 2023 was the memo essentially banning all post-employment non-competes. That's a federal agency. We know in California and some other states, they've been banned for a long time. In my state, non-competes have been unenforceable since 1872. And a number of other states, a minority of states, still enforce non-competes, including Ohio, Minnesota, Texas to a certain degree, New York, a handful of states still enforce in Florida. But in California, we've been living with that for some time. So this is a new challenge for employers. And this May 23 memo was followed by the FTC rule that you all have read about and heard about in the news. It's mentioned in this new advice memo, the FTC non-complete clause rule, which was published May 7, 2024. And that was set aside by a federal district court in Texas, Northern District of Texas, in a case called Ryan LLC versus FTC, August 20, 2024. So we're no longer dealing with that FTC non-compete rule, but now we have the NLRB being even more assertive, more aggressive in policing these agreements. And this time it's extended beyond just a traditional non-compete and attacking what many of employers, including California, often include what the NLRB calls stay or pay arrangements, which typically the employer would say, we're going to reimburse you, for example, for getting additional education for work. But if you leave us within a year, you got to pay back the tuition. That's kind of the traditional stay or pay arrangement that's being attacked in this new advice memorandum. And I will stop talking because I've been talking for way too long already.
Well, that's because there's a lot of stuff and a lot of moving parts, man. I appreciate that quick, and it really was a quick summary of what's been going on both for a long time in the last couple of years. And you're right, there's lots of state action in this as well. In the state where I practice primarily, Wisconsin, in 2023, legislation was introduced to be like California, to virtually ban all non-competes. It didn't go anywhere, but it's a topic of conversation at many levels. And, when you started out, you talked about the board's decision, the general counsel issuing an advice memorandum. But we've also had a 2024 decision that found that non-competes were indeed illegal under the board law. That was in the J.O. Mori case that came out, I think, this summer. And basically, it took what might have been maybe an overbroad non-compete in some jurisdictions, but it found that it would be a violation of the National Labor Relations Act to have a non-solicitation provision that prevents pirating by prohibiting employees during their employment and for 24 months after to persuade other employees to come. It set a non-compete provision that prohibited former employees for 12 months from directly or indirectly engaging in working for another business similar with the employer's business and so forth. I don't know all of the details of the non-compete, but some of it sounded like garden variety stuff, and the board has found that illegal. A lot of our clients don't particularly like non-competes themselves. It interferes with their ability to hire as well as is burdensome. But they think that in some circumstances, it might be really helpful when there's somebody who's highly identified with the company, like a doctor, or when there's somebody who's received a lot of technical training and there's local competition and all of that training is going to be moved over, especially and with the goodwill that employee leaving. And I think it might be reasonable. But all of those are out the window, it seems to me, with these rulings, unless they're overturned. And now we've got the pay or stay provisions. How does that extend the difficulties that employers might have with really organizing their workplace and providing, training and other opportunities for their employees, Tyler?
Great observations, Tom. And I would just add that in California, I mentioned post-employment non-competes have been unlawful in most cases, unless it's a sale of business, the sale of goodwill. Since 1872, we're used to that. A lot of people will tout that law in California for the surge in the economy. We wouldn't have the Silicon Valley. We'd have one company, I guess IBM, and we wouldn't have Cisco and Intel and Oracle and all the other companies that spun out of Big Blue. There's a famous painting or picture, I should say, where all of these executives are sitting around a big boardroom in the 50s, and they all went on to become CEOs of very successful tech companies. A lot of people attribute that to this law in California that very strictly bans post-employment non-competes. You can go to work for a competitor the next day across the street and directly compete with your former employer, at least in California. I view that, non-compete law very differently from the new attack on stay or pay provisions. You can understand why a non-compete would interfere with mobility and upward mobility and getting a better opportunity. Well, you can't compete, so you can't improve your station. But these stay or pay provisions, I think, are more explainable from an investment standpoint. If I'm an employer and I'm going to send somebody to get an MBA or some advanced degree for the job, and they're going to come back and help the company and lead the company, that's a big investment. And I want to protect my investment. And I don't think it's anti-competitive for the employer to say, if you leave early, you're going to pay some of that money back. It's logical. There is no statute like with non-competes that prohibits it. This is the NLRB going out, I think, on a limb and attacking provisions that have been long-standing practice, even in California. These are generally enforceable. So what are stay or pay provisions? Essentially, they require employees to pay their employer if they separate from employment within a certain time frame. Typically, they include training repayment agreements, or what the NLRB colorfully calls TRAPS, TRAPS, educational repayment contracts, quit fees, damages clauses, sign-on bonuses, and other special or similar arrangements. And at least according to the current NLRB, those restrain mobility. Employees might stay longer than they would otherwise because they're worried, if I leave early, I got to pay back half of the tuition, for example. And that's the theory behind this. So there are some exceptions to the enforcement or non-enforcement of these provisions. There's a number of factors that the board outlined in this memo. I should also, and we can go through those in a little more detail. One of the big ones is, does the employee make enough money to justify having to pay back the advance or the tuition payment? And so it's based on their salary and the ability to repay the money. How penal is it if they leave early? But just before I forget, the NLRB in this memo gave employers 60 days to fix any of these provisions that at least according to the board, are unenforceable, the stay or pay provisions. And 60 days expires December 6, 2024. So that's a date to keep in mind. If you have these provisions, you might want to take a look at them. And there's a number of steps the board outlined in its memo, Mr. Abruzzo, everything from altering the repayment amount, changing the stay period, how long to stay, amending the provision to make clear that repayment is not required if the employee is terminated without cause, and of course, notify the employee of this change. Make sure that the agreements are voluntary, and then to stop any kind of debt collection enforcement until you can reach an agreement with a departing employee regarding a repayment obligation. So I will stop there, but this is significant because, again, it's not a state law, it is a federal law, and this National Labor Relations Act, NLRA, the act applies broadly, across the country, employers engaged in interstate commerce, which is pretty much everyone. And there is an exception for supervisors and managers, but it still catches a lot of employees under the jurisdiction of the NLRB.
As I listen to this, Tyler, I think of my clients. I was speaking to folks in the construction industry a couple days ago. And so as I was setting this up, I said, how many of you have open positions? Virtually every person in the room. These were people that were managers, supervisors, and a lot of HR types. Virtually every person in the room raised their hand. And if I'd asked the next question, almost everybody would raise their hand too, which is, how many of you have bonuses to attract new employees? And so sometimes, you got $1,000 or $2,500 or whatever it is to start work. And maybe that's paid out over time, but oftentimes it's a one-time pay. But when you look at it more carefully, oftentimes it's you got to repay this if you don't stay for a year. I'm not going to give you $2,500 on day one, and then on day two, you're off to the next $2,500 roundup, right? So essentially what I'm hearing is that employers are going to end up paying people less. Let's be honest. They're going to say, to heck with that. Why am I going to give that bonus if I have risk that it's never going to pay off in a long-term employee? But the board doesn't seem to care. Am I missing something here?
No, I think that's a really good argument to push back. If employers are going to adjust and say, I don't want a lawsuit, I don't want to be fighting with the board over lost wages and benefits, compensation, legal fees. So I'm just not going to offer the advance, the sign-on bonus, or even tuition at this point, because there's too much of a risk that I'm going to have to not only not enforce that payback, I may have to pay the employee money. So why bother? That's an argument against including them. And you're right, to be cynical about it, a lot of employers will conclude it's not worth it. And instead of giving the $2,500 or could be $10,000 signing bonus, we're just going to forego that, and we'll pay less to the employee. And if they succeed and they perform well, we'll make it a bonus at the end of the year. It's easier.
Well, and the same thing has been true historically with all sorts of folks who may or may not be under board jurisdiction, but assuming that you're bringing in a professional as opposed to maybe a manager, supervisor, executive, and you're having her or him move cross country, and you say you have a $25,000 moving allowance along with, coming out here with your family if you'd like, use that towards hotels and cars and whatever you want to do. You get $25,000 as part of the package to come and see if you want to move to Milwaukee or Oakland or wherever it might be. If that's not tied very carefully to actual value received, if it's not voluntarily entered into, which is the employee says, yes or no, I want to have that, but I recognize it'll be in the form of a loan that will take a year or two of work to forgive. If the board says the time period over which that loan, so-called loan, is forgiven isn't reasonable, it's too long and all that sort of stuff, that too might go by the wayside, or the employer is just taking another significant risk that somebody's going to work there for 2 months. They can't have a non-compete. And then they're going to go walk down to the street to the next clinic, to the next manufacturer, to the next service provider and say, hey, I'd like to work for you. What's that going to do to, employers' sort of analysis of creating that kind of incentive to join the organization?
Yeah, I think it's a real problem. I would just use the California example where employees can do that. They can leave and go work for a competitor. We put a lot of time and effort into defining trade secrets and restricting use of trade secrets as opposed to contractual covenants not to compete or covenants not to solicit customers or employees. But that is a risk. And, these provisions that are being attacked, I'm setting aside now the traditional non-compete, but the pay or stay are problematic. That employees, if you're cynical about it, they've been doing this for a long time, and you assume the worst in human nature, you're going to have employees who are going to take advantage of this. I think they're very increasingly savvy about this stuff. They're going to take the money and then they're going to say, no, 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 you can't touch me. Go talk to the NLRB. How does an employer deal with that? One, you may not be able to attract the talent in the first place without offering a sign-in bonus. It might be a non-recoverable bonus, under this new guidance to avoid a claim. But I see all kinds of mischief here by extending this rule to pay or stay provisions and requiring employers across the country now to rewrite their provisions by December 6th. I don't think a lot of our clients understand that they're going to get challenges come January to some of these arrangements that are in place.
I love that. And I think we'll wrap up with just two things that are on my mind. One, you talked about really a much more sophisticated approach to protecting confidential information. And again, the board says certain confidential information can be protected, but it can be overbroad. So you have to be very careful. And the second one is what happens if you're found to have violated this. So just a sentence or six on the kinds of ways in which employers should be very careful about, but can use some protection for their goodwill, their intellectual property, that sort of thing.
Yeah, so this is still evolving, but at least according to this recent memorandum from the General Counsel, the General Counsel has come out and said that she will seek rescission of the unlawful stay or pay provision and require a written notice to all affected employees that the stay obligation has been eliminated, any debt has been nullified, they can leave in peace and not be sued and not have to pay back the money. So that's rescission of that contract. Lost wages and benefits for employees who claim they were discouraged from pursuing a better opportunity by the unlawful provision. The General Counsel will seek compensation for those individuals, the delta between what they would have made at a new job and what they made by staying at the current employer. So that's a real wild card. Compensation for repayments made, so that if employee honors the agreement, they pay back the money. The NLRB General Counsel, at least here, is saying that they may require the employer to pay back that money to the individual. So that's money that's already been paid to the employer to pay back a loan, to pay it back to the employee. Legal fees, collection fees, harm to credit rating, and financial harm are all on the list, on the agenda of the General Counsel to redress, and even additional financial and pecuniary harms. And this example that they give is an employer could be required to pay for moving related costs if an employee had to relocate to obtain employment within the industry and cover the cost of any retraining efforts undertaken. They may be able to get that money back from the employer for a violation of this exclusion of stay or pay provision.
It's a brave new world that employers live in, and it may just cost more to hire people. It may cost more to keep people. There may be fewer certainties about protecting what you believe was goodwill that you invested in an employee and that sort of thing. But that's the reality. Is there any possibility, by the way, that a court's going to say, no way, this doesn't really fit into the National Labor Relations Board? Protected and concerted activity, you're really stretching the definition, under Section 7 of what it is your role is. Back off. And is that possible?
Yeah, I think anything is possible. Tom would probably know better than anyone. It takes a long time to challenge a ruling by the board or a finding by the board. There is an appeal to the DC Circuit. Well, first to the full board. It's unlikely the current board is going to overturn Ms. Abruzzo's advice memoranda. It may change with a change in administration on November 5th. There may be changes to a lot of what we've been talking about for the last 2 years on the labor law insider. Absent that, a challenge in court, the DC Circuit, or whatever circuit the alleged unfair labor practice occurred, is another avenue to challenge this, but that takes a lot of time. And conceivably, even to the U.S. Supreme Court, especially if there's a divergence of law on this issue of pay or stay, or even the non-compete, which is still in the last year's advice memoranda.
Yeah, but let's be clear. There's an awful lot of deference to the board in interpreting its own law.
Right.
And the breadth with which laws are interpreted by administrative action, it's one thing, but by advice memoranda consistent then with decisions that are made after that, not an easy challenge.
Right.
Sometimes, and we've seen courts recently say, "Hey, board, you're kind of cracked up here." But if you're a betting person, you don't put a lot on that bet, in my estimation.
No, the better bet is we get a more business-friendly board in place, and a lot of these rules that were changed from the Trump board will be changed back, or at least softened for employers.
Yeah, and here's a blue state lawyer from California talking about maybe a change. I'm in Wisconsin, a very purple state. I've got no predictions to offer. So.
Yeah, I'm not in the predicting game. I just know that the board policy, it shifts dramatically based on the elections.
The famous adage that elections have consequences, and that's certainly true when it comes to national labor relations decision-making, even though the NLRA doesn't change much or the LMRA doesn't change much from decade to decade. The interpretations sure do. Hey, Tyler, this has been awesome. Thanks so much for jumping in on this very important topic. I hope that a number of our listeners are now alerted to the December deadline, and we'll take steps accordingly. And certainly, if this is important to others in your network, share the podcast. Share the word. We also have a labor law alert on this that you can find on our Husch Blackwell website, and I think we'll have that probably in our podcast show notes that you can get to. So we'd love to have you share the good or bad information, certainly the timely information that we try to offer in our podcasts. And thank you so much for joining us, Tyler, on the Labor Law Insider. Really appreciate it.
Thank you, Tom. It's been a pleasure.
And thank you, our audience, our friends, our clients, for becoming Labor Law Insiders. Take care.